Online Visas, the intelligent immigration platform, offers the full spectrum of business visas that a company could use to employ a foreign national. Here's a breakdown of those visas. The H-1B is for specialty occupations. These are for jobs that require university degrees and that the individual that will be working that job has that specific degree. It's only available for specialty occupations, which have been limited over the years. We can help you understand whether or not your job and your beneficiary meets those qualifications. The H-2A visa is a temporary agricultural visa. This can be both seasonal or peak load and requires the company to pay for housing and other incidental events as well as the filing fees and costs. The H-2B visa is also a temporary need visa. It's for the non-agricultural types of jobs. It does not have the requirement of providing housing, but it has a lot of limitations on it that you need to know before you file. Both the H-2A and H-2B and H-1B have numerical limitations, meaning that they have caps that can be met, and many times they meet them quite quickly. We are glad to discuss these elements with you if you're thinking of hiring somebody under these visa categories. The L-1 visa has a couple of categories. The L-1A is for executives and managers of international companies that want to transfer those people in those positions to their U.S. operation in either of those positions. So you can be an executive in the foreign branch and a manager in the American branch or vice versa. It also has the L-1B for specialized employees. Those visas are only good for up to 5 years, while the L-1As are up to 7 years. The L-1A can lead to the EB-1-3 green card for multinational executives and managers. The L-1B is not so easy to make that jump, and you must look at either the EB-2 or EB-3 under PERM in most circumstances. The E-1 is for the treaty trader. These are for companies that have substantial trade with the United States and their home country. That substantial trade needs to be at least 50% of the trade with any foreign nation. The E-2 is for the treaty investor. This requires a substantial investment. The Department of State, which are the consulates, require over a $100,000 investment. The USCIS can do it for less than that, but there are best practices you need to look at. You need to have some employment, not as much as you need on the L-1A. In the L-1As, to go back to that, you need to have 3 tiers of employees. That means executives, managers, and workers in both the foreign and domestic location. In the E-2, you don't need to have that, but an E-2 can't work if someone's just creating a job for themselves. For example, they cannot just merely be a consultant that does this work for others. They must hire others to help them do it and oversee that employment. We can tell you how to do that. Both the L-1 and the E-2 require business plans that are written under the requirements of the matter of Ho. This is a case that immigration looks at when it's determining whether or not the business is sufficiently described. We can help with that, and we do for most of our clients. The J-1 has a number of different visa options. 2 that are related to business are the trainee and the intern. We can help develop those plans and work alongside a J-1 issuing company to get that type of visa for you. The H-3 is also a trainee visa. These have become very complex. You need to develop an entire program of documentation in addition to showing what the itinerary will be, as well as other things for this type of visa. We can help with all of that. The O-1A is for the extraordinary ability, and this is for the sciences, arts, education, business, and athletics. These are very interesting visas because it's for the very best who have risen to the top of their profession. There are about 8 different criteria. You must meet at least 3, but in addition to that, show that the beneficiary has risen to the top of their field. This is based on excellent expert letters that know how to analyze the 3 tiers of evidence. Those 3 tiers are primary, such as awards, membership, paychecks, contracts, things that are tangible. Secondary, which are expert letters or witness letters from those who need to give testimonial evidence, such as the duties. It is very critical to know how to use those letters and that evidence to win these cases. They are very difficult with immigration at this time. The O-1B is also for extraordinary ability, but for the film and motion picture industry. It also requires good analysis from experts, but those criteria are a little bit different, and there are important factors to understand the plain language of those regulations and how to make that evidence work for this type of visa. The B1, B2 is the visitor visa. This can be a very critical visa when you're wanting to set up a company in the United States, interview for a job, or come over and do some short-term work as long as it's done correctly. These can be very easily denied. They're very discretionary, but we can help develop a suite of documents that help you win your case. The green cards under the business immigration factor are as follows. The EB-1-1 is for the extraordinary ability. This is not only like the O-1A, but also like the O-1B, but is more similar to the O-1A in the types of questions. The difference between the EB-1 and the O-1A is sustainability. Person has to have stayed at the top of the profession longer. They're also just looked at with a harder eye. It's important to really understand the difference between an O1 and an EB1. They're not the same, and you cannot just argue because someone received an O1 that they should get an EB1. We can help with that sort of structure. There's also a phase 2 analysis under the Kazarian case. It's important to identify that the beneficiary not only meets the criteria under the first prong, but also the second prong, and also knows how to use expert testimony as well as witness testimony. The EB-1-2 is for outstanding researchers and professors. This requires a job offer from a university or a research facility. The EB-1 does not require a petitioner. It does require some element of work, though. That element does not have to be paid and does not have to be extraordinary. But in the EB-1-2, it does have to be a university or a research institution. It has a somewhat lower standard than the EB-1, and we can help you analyze that. It also has the need for evidence and expert and witness testimony. The EB-1-3 is very similar to the L1, as discussed earlier, because it's for multinational executives and managers. That does not work for the L1B, just for the L1A, those in that capacity. You can come over on an L1A and toll the requirement having held the position in the overseas company or the foreign company for one of the last 3 years. If you held it for one of the last 3 years and came over on another visa, L1 and maybe another like an H1B, it will toll that requirement. It's also important to understand how to deal with people that own very high percentages of the companies that they are transferring. We have techniques on how to develop boards of directors or employment contracts where that employee is an employee under the Darden versus Nationwide Supreme Court case that lays out a number of issues on how someone is considered an employee, which is a critical element of that green card, as well as the L1A. The EB-2 national interest waiver is somewhat like the EB-1, except that it has had a long history of evolution between a couple of cases. First was NYSDOT, the New York State Department of Transportation case that made it very difficult to get these types of cases. That was overturned a number of years ago by the matter of Donisar. The matter of Donisar made this visa a really good choice for entrepreneurs who are creating jobs in America. It is a fantastic way if you don't meet the EB-1, but you own your own company and you want to get a green card, to use the matter of Donisar analysis under the national interest waiver under the EB-2 green card. The EB-2 and the EB-3 under the PERM process utilizes the labor certification. The labor certification is a process in which the employer samples the job market by putting a series of ads in 5 different manners out over a period of time. That helps understand if there's any Americans that are willing or able to do the job. The trick to these visas is to understand how to frame the job without tailoring it to the beneficiary. You're going to look at 3 different things. One is, how does the company typically advertise for this job? If it typically requires 2 years experience, and this time it's going to require 12 years experience because that's what the beneficiary has, that is called tailoring. You should also look at the SVP. That's the Specialized Vocational Preparation methodology that is used by the Department of Labor. The SVP may say that this job typically requires 2 years experience, plus a bachelor's degree or plus a master's degree, whatever it may be. In that circumstance, if you require more than those years of experience, you should look at that and upfront put it in the labor certification under the category of business necessity. Now, you can win business necessity, but it's not a good idea to try it after they've already audited your case. If they audit your case, it's about a 50% chance of denial, and it'll take about 2 years longer. So identifying business necessity and what the requirements are for the job up front and whether or not the beneficiary has it at the beginning of the process and not later are the keys to success for the EB2 and EB3. The difference between an EB2 and EB3 is that the EB2 is for an advanced degree professional or someone that has more than 5 years experience. The EB3 can be based on having a bachelor's degree or not having any degree or any experience at all. We can talk to you about whether your job and your company meets the qualifications for those visas. The EB4 are for religious-based visas and other miscellaneous types of green cards. Religious-based visas have to be for religious occupations, such as rabbis, priests, preachers, those types of things, not for somebody who merely works in a church. That is the same for the R visa, which we did not discuss above, but would be considered another business-related visa. The EB5 is for an investor visa. That is when you invest either $900,000 in what's called a target employment area. Those are either rural, meaning that the area has a small population, but it can't just be some component of a city. It must be outside a metropolitan statistical area, or it has a high unemployment rate, which is about 1.5 times the national average. That place can be determined to be much smaller, and there's been a lot of discussion on the change of that recently. One way is the regional center. This is where you invest in a predetermined area designated by USCIS, which will have numerous slots for the investors in these lower increments. The other manner is what's called an EB5 standalone. That's where you may invest in a company just by itself. There can be any percentage of equity ownership in that. Unlike the E2 that we talked about earlier, you must have a 50% ownership. But for the EB5, you can have a fractional ownership. It doesn't matter. As long as you invest the requisite amount of money and create 10 full-time jobs for Americans or green card holders.